Hello and welcome to today's National Eviction Team webinar on the environmental and fracking site protester removal. First things first, can you all hear me? There is a question box in front of you. If you could let me know if you can hear us, that would be great. There we go. Yeah, okay, good. Technical tour in front of you. Question box is there to ask questions throughout. We will be answering questions at the end of the webinar. If you've got any other issues, that's how you should communicate with us. Quick disclaimer: please treat the contents of this webinar as food for thought, but don't take any actions based on its content unless you have taken legal advice. The speakers cannot accept responsibility for any errors or inaccuracies, loss or damage unless we have given you personally specific advice relating to a matter about which you have given us full background details. You must also bear in mind that the contents of this webinar are based on English law, and because it contains archival material, that material is bound to go out of date. The aims of today's webinar are to provide sufficient understanding to commercial and statutory authority landlords and landowners of how to evict activists and protesters from property and land, including protesters against fracking, infrastructure, nuclear and expansion projects. To consider what practical and regulatory matters will affect gaining vacant possession and plan how to deal with such issues that arise. To consider, predict, mitigate commercial and reputational risks, and also to understand what compliance and service standards your chosen High Court enforcement officer should demonstrate and deliver. The agenda is there in front of you. I won't read it out because you can read, but we will be, it's very straightforward what we'll be looking at. Who I'm joined by today. Firstly, I've got David Asker. David is the Compliance Director and Authorised High Court Enforcement Officer at the Sheriff's Office. He has over 35 years experience and is currently elected Director of High Court Enforcement Officers Association.
Good afternoon, everybody.
Hello, David. I'll move over to our other speaker today is Gary Boven, who's also been in the industry since 1987. Plays a key role in the National Eviction Team in its operational and on-site enforcement, has served as a Director of the High Court Enforcement Officers Association and is working on the education pathway. His other qualifications are there in front of you, but I will now happily hand over to the two gentlemen to my side.
Good afternoon. As you can tell, you've got two very well-versed, experienced High Court Enforcement Officers.
He means old.
Oh, being kind to you, David. What we're going to do is go through each stage and the importance and talk to you about the issues on a practical level, because we do this on a daily basis, whereas obviously some of the audience out there, it's unique to them or as and when the job comes across their desk. We deal with several types of possession, including compulsory purchase orders, where we see protesters. Orders for sale, very rare, but we will discuss one throughout the presentation. Residential tenancy, which is straightforward when the landlord's trying to evict somebody. Commercial premises non-trespass, and peaceable re-entry through CRA. So we have a vast array of information all funneling into this specific topic. It's a small audience today, which expresses how unique this subject is. However, please don't be a stranger. Don't let the problems mount up on your desk. We are contactable and our details will be available at the end. So we'll go through the main structure of it, and the biggest thing to accept is the mindset on each one of the individual types of possession we do. As you can imagine, a tenancy eviction is different to a traveller's. Travellers just enter a process, and as long as that process is a day two, we then move it forward fairly quickly. However, protesters and a mindset completely. The main thing about them is they are not adverse to putting themselves in harm. They will set themselves up at heights underground and put booby traps in the way to prevent the enforcement from going any smoothly. So we're going to capture some of those things as we go through, because we will be giving examples as well as giving you practical advice. The main thing that everybody mistakes is engaging with the High Court Enforcement Officer too late. I and David both get clients coming to us saying that they've got the complex possession, they've got it through, they've got it sealed, they've got me named as an officer, and can I do it on Tuesday? So we're going to go through some of the things and common mistakes large-scale evictions do, and one of the biggest is late engagement, because it delays in the planning, the operational risks. As we go through the presentation today, you'll see how all these pieces fit together in a jigsaw. But the main one is the bottom one, police assistance. And the police are very particular, especially at silver level, which is chief inspector level, that they have to have everything in place prior to them committing to a case or giving assistance. And they are one of the key stakeholders, which we'll talk about the police as we go through the process. But ultimately, it has to start at the beginning, and the beginning is through the court.
Yes, right. Well, now, when it says here the majority of cases are heard in the county court and exceptional cases may be heard in the High Court, it is human nature to think, oh, my case is exceptional. These protesters or these trespassers are really painful. They're causing my client or myself huge harm and damage. It must be a case of the High Court. Alas, no. I have read Senior Master's Practice Direction, and I can give you a practical example of the kind of case that can actually be heard really quickly, same day, in the High Court of Justice. A little while ago, at Easter, and my long-suffering wife long ago learned never to plan anything over the bank holiday weekend, because on the Thursday before Easter I found myself in the morning the recipient of a panic-stricken phone call. Occupy-type protesters had entered Admiralty Arch. That's a landmark in the middle of London, right opposite Buck House. Now, on this particular day, it was even better, because for those of you who remember the news a few years ago, there was a huge fire in Kingsway which took out all the phones in the Royal Courts of Justice. So even if they could be heard in the High Court of Justice, how were they going to do that when it was closed? Well, they specially opened the Mayor and City of London's court over at Guildhall, and the judge went and sat there, and because the whole of London was gridlocked, the Cabinet Office solicitor cycled her way from her home into town and was heard, and the writ was duly issued at 6:30 p.m. and bicycled over to us, and we dealt with it that very same evening. The circumstances were massively damaging to the premises. The costs were astronomical. There was physical damage being done. There was theft going on. That's the only way you'll get it through the High Court of Justice. So what I've taken a very long-winded way of saying is, it's got to be pretty darn serious. So most of the time it'll go be heard in the county court, and at the end of that you obtain your judgment or order, and you will ask your High Court Enforcement Officer to transfer it up to the High Court for enforcement.
So ultimately what David's explaining is that it has to be against the trespassers, and the slide which are going to be available at the end is the checklist, and it's got to be a serious risk and substantial. I know it's serious to you and your client, however there are loops to jump through, but by all means have a discussion with us, engage with us earlier on, and we'll see whether or not it would be exceptional to use this method. So general forms are used?
Yeah, it's the same as any other form of possession. You simply go through its trespassers. So effectively, notice has to be served, and we get to a point here where we all start to differ, because everyone thinks, oh, serving notice of hearing, I just want this to happen quickly. But serving notice of hearing is a huge golden opportunity to plan the operation to go as smoothly as possible.
Here's a practical example. two of our officers thought a general day going down and serving the general notices. This was a particular fracking site. The officers got out, quickly surrounded by 30 very excitable protesters, what we would call hardcore, David.
Yeah, it's crusty, it's hardcore. They're used to doing this. They really believe in what they're doing, and don't underestimate that. Yeah, this is England. They've got a right to do this, but sometimes it can go too far, you think.
Because ultimately what occurred was the two officers were badly assaulted. They managed to get into their vehicle, and the vehicle was caused exceptional damage, with all the windows being smashed and shattered. And ultimately, what it was, even though it wasn't good for the attending officers, it was a good grounding for us to start doing the operational plan based on the reaction. So don't think that the service of notice of a hearing is just an incidental. Again, if you've engaged with us early, we can get involved with this, and it gives us a taste of what the reaction is. And ultimately, that reaction is transferred into the operational planning risk assessments, which we're going to go through, and stops and prevents the eviction not being completed, or more importantly to you and your clients, it balances out the matter against costs. Because ultimately your client doesn't want to be paying any costs that are not necessary. However, from serving of the hearing, we can quickly establish where we need to pitch the operational planning. David.
Right. Now, it's a bit like Mrs. Beaton's recipe for jugged hare. First, catch your hare. Once judgment is obtained, that very small 4 words, there could be a whole world of grief for you in that, getting the judgment. But once you've got your judgment, you need a writ required for enforcement. Getting your judgment, the reason I say it can be problematic, I have dealt with several cases involving protesters, particularly fairly high-profile protests, whereby judgment was delayed in being obtained because no provision had been made for lawful protest. Now, this may apply more to our statutory authorities, or landowners, but certainly in a couple of instances where fracking had gone on, the initial approaches to obtaining a writ were stymied because the pro bono lawyers representing the protesters had said, well, hang on, you know, my clients do have a right to protest. Where are we going to do this if you block the entire site to us? It is not necessarily inimical to a successful operation providing a legitimate protest area. It comes up a lot in some of the work we do, and it's extremely important. I've stressed this point because I would like you to remember it. Anyway, assuming you've now obtained your judgment, you request the writ from the court issue office using the standard forms. Forgive me if I'm teaching grandma to suck eggs, but it's sometimes forgotten about. Also, because these things come up very occasionally, certainly some of the people I speak to in the Association of Chief Estate Surveyors, they say, well, this happens once in a blue moon. What on earth do I do? Just pick the phone up to your chosen authorised officer, they'll tell you. The writ itself is Form 66. Now, bold, very, very patronising, isn't it, to put stuff in bold? I make no apologies for that. Must include the named authorised officer. It's no good issuing a writ assigned to the officer assigned to the district. The High Court Enforcement Officer derives a lot of his powers from statute. If you haven't got a named writ, it gets quite difficult telling the police, no, it's not a question of optional whether you help us. You are required under the Courts Act 2003 to render assistance to the authorised officer and his enforcement officers. It needs to be named.
It can cause delay by not having somebody named as well, because both David and I and the rest of our authorised officers only feel comfortable doing them when it's actually the named enforcement officer. Which would mean that even though you've got a sealed writ, we'd have to send it back to court to have it amended and button sealed with the relevant High Court Enforcement Officer's name being applied. The important thing is, if you've engaged with somebody earlier on, then this will all be in place and everybody will be all being ready.
I mean, a good example, next point, issue offices can take considerable time to prepare and issue the writ. Yes, I know, Department of State, the obvious, isn't it? But we know, for example, your authorised officer will know which court may be in a position to act quickly. Now, funnily enough, this webinar is brought to you from Fetter Lane in London. Less than 100 yards, I know because I've walked it often enough, from the Royal Courts of Justice. 2 or 3 times a week, myself or my glamorous colleague, Rachel, frequently haunts the Master's Corridor, getting writs issued quickly. The issue office there, they know us. They know if we turn up, it's a fair bet that all the paperwork is going to be in order, in, out, done. So engage early with your authorised officer. Sorry to labour the point, but things like that would sometimes escape people. Now, it is important, once you've obtained the writ, it must be lodged with the High Court Enforcement Officer to whom it is addressed. What does lodged mean? Well, again, under regulation, under the TCE Act 2007, the authorised officer to whom the writ is addressed, upon receipt, must endorse the writ on the front with the date and time on which he or she received it. So it's no good saying, oh, I got the writ here, I'll send it to you next week. As soon as you've got the writ, get it to your authorised officer. As soon as it's been lodged with him or her, it is effective.
We've even had them courier them from court to the site where we've had pre-preparation, pre-operational planning so that we could effectively engage with it. However, it is very, very important that the lodgement is with the enforcement agent very early on because of the police and the other stakeholders which we'll be going through and speaking about that importance very shortly.
Okay, planning and preparation, common variables. You sound like a school algebra lesson, isn't it? I keep saying this, I can't stress this too highly. But effectively, the success of the operation will depend on how diligent the planning has been. Planning and preparation, stakeholders. Yeah, obvious, isn't it? Not all the stakeholders are that obvious. You may well have be owners of a piece of land upon which you are unfortunate enough to have trespassers who are protesting about something or other, or just fairly crusty trespassers who don't want to move on. Those around you could be the Highways Authority, will certainly be the local police, could well be local authority social services, because one of the things that protesters do is and you'll have seen this, those of you who watched the news over the recent bank holiday weekend, with the number of protesters and hangers-on below the age of 16. Social services will need to be engaged there sometimes. These stakeholders aren't immediately obvious. One of the good things with the authorised officer, he or she will know who is to be engaged in this and will act almost as a fulcrum around which the whole thing pivots. Identification of land and premises. Obvious, isn't it? Well, not just last week. It's not obvious. Last week, I spent a very energetic morning with, well, put it this way, by the end of the operation, each of my boots weighed over 11 kilos because the clay was lovely. And I was walking up and down, not for the sake of my circulation, but because the land plan that had been obtained, and we'd gone through the planning on this, and I'd said we need a detailed copy of the large-scale land registry plan. That was not forthcoming on the day. So we made best with what we got, but it showed a footpath on the inside of the boundary, a public footpath. Now, this particular plan, derived from the land registry, had been drawn up at about in the late 1940s. Many years have passed since then. This footpath was at the bottom of a little 2-foot bank. On the ground, something I pointed out during the planning stage was that the public footpath was at the top of the bank. The sign that said public footpath was at the top of the bank on somebody else's land. And the point was the land registry plan certainly showed the public right of way had been dotted down the bottom of the bank. But of course, nowadays we aren't as hard as we used to be and don't like walking in the mud. And so they'd all walked to the top of the bank, and that had become established as the public right of way. It had been there more than 20 years in use, and indeed signposted as such by the council. Caused a bit of head scratching. It was gotten around. However, I cannot stress highly enough, you have to correctly identify the land and or any premises on it. to which the writ applies.
One of the key things is if we're having to take people off the land, we've got to know where the boundary is, because they can move to an area which is still part of the land and premises, which still falls under our jurisdiction to remove them from. So it's important to identify the perimeter of the property.
Yes, planning and preparation, stakeholders, so on. Now we move on to the risk assessment. Take a look at the photograph. That's what happens when somebody doesn't want to leave their home under an interest-only mortgage in the middle part of the country. First time the county court tried it, they had 320 protesters and hangers turned up to prevent it. The second time we were asked to be involved to plan the enforcement side of it, and I think we had 120. That wasn't that photograph. That was the second time it was attempted. I think there was about 180 there, and then the time we did it, we had 120, but they were on the outside of a police cordon.
So what you've got to do under the risk assessment is don't underestimate the use of media, because it can actually be to tell us what's going off. It can also be information gathering, and social media is a strong element nowadays, whereas 10 years ago, David, it wasn't. It was
word of mouth and
local
issues.
issues.
Yeah, local issues, word of mouth, a few phone calls. Now with social media, you can have rent-a-mob turn up within half an hour. They can and do. However, it's a two-edged sword. Putting it out on social media is pretty handy for us as well, because we know who's coming, and also the amount of misinformation. We've had a job recently where it was out there, yes, they're all coming in this particular week, and gosh, we didn't turn up for another 2 weeks, by which time all the cry wolf support kicked in, and when they went, oh, they're here, nobody turned up. So it works both ways, but be aware of it. And in a large operation, the police will generally be all over this. I never cease to be impressed, actually, by the level of sensible intelligence that the police forces have around the UK. It's not what you would think it will be, but the amount of chatter out there that just gives an idea of intention. Quite often it can be useful, because sometimes there's chatter about supporting the protest, but it's entirely clear that it's going to be a peaceful protest. It's not actually going to have that much effect on the operation.
So which leads us to intelligence, because intelligence can be as simple as, or when the process server went round, they said they weren't going, or she had a baby in her arms, or he could see that there was a tunnel and there were up trees. Any information is intelligence information. You please obtain it from your client, obtain it from information over your own desk, but more importantly, pass that intelligence on, because even though it might be minor to you, with our experience, we can use that to its full capacity in the operational planning. And it also, when we approach the police, it helps that we've done some background information as well, which moves us on to the health and planning side of things.
Yes, okay. Well, health and safety planning, I'm sure you're all dreading the moment we mentioned that. Well, in my experience, it's nothing to be afraid of. Now, I very early on engaged with this and thought, okay, I'm dealing with highly qualified health and safety professionals within the police force, sometimes on the client side as well. It behoves me to be equally qualified. I'm a NEBOSH General Certificate holder in Occupational Health and Safety. That's useful at all sorts of levels. It completely demystifies it. We had a very large corporate client. We had a very large health service client who had a problem with some buildings occupied by some fairly robust and crusty trespassers. Not protesters per se, but they were quite good at latching onto any local issues and making out they were protesting for that, climate change, etc. Now, all these buildings are Victorian, and they were apparently badly asbestos contaminated. And this had basically made them very, very reluctant to enforce. However, upon examination with qualified licensed asbestos removal contractors, it became quite clear that unless you went in there with a large yard broom and a baseball bat and started disturbing some of the building rubble there, and then got down on all fours and started sniffing, the likelihood of asbestos exposure was minimal, provided sensible precautions were taken. The operation went ahead extremely smoothly. Each of the 4 sites took less than 2 hours to deal with. It simply says that be aware that the health and safety planning is not necessarily an onerous process that will slow it down. It quite frequently makes the whole process run a lot more smoothly, plus the fact it is the avowed intention of a lot of protesters to make an operation difficult to do by putting themselves in harm's way, by making it dangerous. Effectively, these threats can be mitigated through proper planning. Compliance planning, the same. We have to make sure that everything is done is lawful and proportionate and safe. Compliance planning with various regulatory compliance is an integral part of the planning process, and more importantly for you, reputational management. Not just the client's reputation, but the reputation of Her Majesty's Courts and Tribunal Service and the reputation of the local police. It all depends on a sound plan. And I cannot stress too much. In fact, I'm Mr. A. Mr. B will now announce the watchword, which is
engage with the HCO early, because we are professionals in dealing with this. We'll bring it into the necessity for the operation, and we'll quickly establish parts of the planning to bring the reputational management to a very small amount. Vacant possession, that's very important. When you're doing the operational planning, the definition of vacant possession is not always clear. Our role is to give you the premises back, but it's also important to find out how we're going to deal with it, what we're going to do with any assets that are left on the land, but we'll cover that shortly. The recommendation here is always obtain a writ when it is involved with fracking full protester squatters. It's exceptionally important because you don't have the same rights under common law. People think, oh, well, we can do this as a trespasser under common law. When it gets to this level, it's above and beyond that, and you want to be getting this through the court process. David, what's reasonable force?
Yes, well, there you are. This is where it all hinges on. What is reasonable force? Now, for example, if you, the landowner, says, well, under common law, I can use my agents, which could be anybody, it doesn't have to be us, to attend and use reasonable force to remove the person. That person resists, and you then have to carry them off. That's fine. But if the people doing the carrying off, say they're ordinary security agents, they've got an SIA license for dealing with door supervision, so they're trained to carry people, to remove people from the premises. Effectively, my contention is, based upon long experience, that the level of force they can employ to remove a person from the land as an agent of the landowner is not the same as the level of force that a High Court enforcement officer and his experienced enforcement agents can use under those circumstances. However, the police may well take the view, irrespective of who's better qualified, the police will take the view, hold on, your presence here is causing an affray. I'm not obliged to do anything other than keep the peace. So unless you desist, I'll arrest you all. Under a writ of possession, it's different. The police are obliged by statute under the Courts Act 2003 to assist at the request of a High Court enforcement officer, that High Court enforcement officer or any of his agents, if they are engaged in enforcing a writ issued out of the High Court.
One of those teams that we undertake is the responsibilities, and we have several different teams which we'll go through. Undertaking initial site assessment is imperative. Conduct of the operational planning, all these feed into each other. We do a standard operational process, and we take into account any public risk. We do a RAMS method in statement. This sounds very long-winded and extremely complicated. However, we do it on a regular basis, so it's pro forma for us. But what's more important, the police won't engage unless these are all in place, and we're finding that more now, aren't we, David?
And having standard operating procedures, it's effectively over the years we have built up a large library. There isn't much that comes up that we haven't seen before. The planning process is thus necessarily a long process. Having these standardised documents in place that are adapted to suit the circumstances means we can engage very quickly with the police. Everybody is comfortable with it. It moves ahead.
What we've got to do is engage with all legislation and human rights issues. People always grimace at human rights, but people do have a right to be able to demonstrate, but they've to do it within the law, regulations.
Now, there might be a few of you that will say, well, hang on a minute, I'm not a statutory body. Human Rights Act doesn't apply to me. Ah, yes.
It does to us.
It does to us. The writ was issued out of the Her Majesty's High Court of Justice. Therefore, the HRA applies. It isn't onerous. It simply requires that actions be proportionate and we engage in communication. That we do anyway. That's why we're so successful.
The risk management is a really good, strong part of looking after everybody. We also have a duty to look after the protester, and grimace at that as well. However, we have a duty of care, and that's done through the risk and management. In that risk management, when we've done in the site induction and looked at the sites, those hazards will be fed into the operational planning, which can take, on a big operation, 2 weeks to prepare. It's everything the same, planning. It can take 2 weeks to do, however, it can take 2 hours to complete. If you hadn't done that 2 weeks planning, it would have been more than 2 hours to complete, trust me.
Well, the job I did the other week, there were 25 officers deployed, deal with a fairly large piece of land. In the week and a half previous to it, there had been 8.5 hours of planning, various phone calls, getting it all organised, meetings. The job took 5 hours to do with no incidents and nothing reported in the media. It just went ahead.
The reputational risk was maintained.
Absolutely.
Training is imperative, and we concentrate this side of it very seriously. All the enforcement agents that we use train to a very high standard, and they specialise in particular parts. Warning the occupants, this varies on a case by case. If it's a single occupant with a tent and they're going to be moving on, then to warn them and give them a heads up that we're coming on the Tuesday is sensible, because the likelihood is that they're moved. However, there are consequences as well. So engaging again with the professionalism of your authorised officer will show you and put the balance scales out, because on occasions it'd be silly, especially where items have been identified as using lock-ons. Use of force, we have the ability to use reasonable force. The operational plan will cover securing the site. Once we've got control of it, how we're going to secure it. Are there any goods or abandoned goods on the property, and how we're going to deal with that under torts. Searching premises, especially buildings, for occupiers, because we've had the sneaky one hiding in the loft or the cellar.
Oh yes, that's an old favourite. It's kind of a game of hide and seek. I know it sounds rather amusing. It is an important part. The last thing you want to do is leave someone in there who's going to act as a Trojan horse. Or, indeed, occasionally people are left on site because they're incapable of going anywhere else. I have removed several ladies and gentlemen under the influence of various substances that, had they not been located, they could have been there the rest of the day. It needs to be done properly.
We've also to be mindful as well of any unlawful activity, whether or not it's been used illicitly. There's been special plants growing historically.
Well, we've had everything, including illegal film studios, which I won't go into detail of, but a bit of an eye-opener. Again, a lot of this comes out of the intel briefing. Sometimes you find stuff that nobody was aware of, and then actually you need a plan to handle this so that we can get on with the job on the rest of the site while the police go and do what they need to do. Because the last thing you want is, there's a crime in progress, we'll shut the whole site down. Generally, we can work our way around that, having a proper plan. Fail to plan to fail. I have used to Hackney's phrase. And most importantly, post-eviction security.
Where the site is being secured, we've got to ascertain whether or not we're going to put fencing up, whether we're just handing it across to the landowner and it's theirs. we can assist in that, and effectively we have resources to be able to deal with it also. Other things that we've got to do is talk about contaminated sites, if you're aware of it. This particular photograph.
Oh, I recognise that. That was the one I lumbered you with, wasn't it?
Where it had been unoccupied for several years, nearly 5, and nothing was growing on the land, which
I wonder why.
it had been used as an illicit dump. Vulnerable persons. Vulnerability is exceptionally important. It doesn't prevent us from conducting the enforcement of a writ of possession. However, vulnerability is taken into account, and all the training that we've given, and the enforcement agents deal with is through the vulnerability side of our training packages. And violence and other hazards. If somebody has been aggressive to your agents, to your landlord, to your client, then please notify us straight away, because we do have regulations to operate under ourselves, and these are the health and safety issues and working under the Health and Safety at Work Act.
Yeah, I mean, control of substances hazardous to health. That site we were just looking at, there was told that there had been some chemicals dumped there. Clearly nothing was growing. The simple precautions were taken. It did not prevent us from any way. Well, I say us. I was on holiday at the time, but my colleague, Mr. B, was quite happy to deal with it. I think, and you're still here, so clearly the health and safety aspect worked.
Yeah, the salts and the bolts have disappeared, but yeah.
Brill. Firstly, we're going to have a quick quiz, guys, and then we will return to the webinar. So there'll be a question that will be coming up on your screen now, and that is, why is it important to engage early with the High Court Enforcement Officer? Is it to reduce the delay, establish the best course of action, early engagement with the police, or all of the above? We'll give you a couple of minutes for you all to get your votes in. But it looks largely like you are correct, and it is 100% all of the above.
Yeah. Common sense, really, but then again, you know, it's I can see how it comes about.
Question 2. Which form is used to request a writ for an order issued in the county court? Is it an N293A or is it a PF86A? And that should be on your screen now. And it looks like we got the right answer. Gentlemen, the right answer is?
N293A.
It is indeed.
If it's issued in the High Court, the PF86A.
Question 3. When can a case be heard in the High Court? Is it when there is substantial risk of public disturbance or harm to a person, the property or land is of very high value, or where there is valuable livestock on site? Ooh, bit of a split on this one. Gentlemen, which is the correct answer?
It's when there's substantial risk of damage and harm. It's not the monetary value, because that would really be unjust.
It would be very unjust.
It's going to be something of national importance. If it's going to appear on the news at 10, then you've got a chance of getting into the High Court. Otherwise, don't bother.
And then the final question for this part is, what is reasonable force when removing trespassers? Is it safely carrying people from site, using a locksmith to gain entry, safely removing barricades, or all of the above? Just wait another few seconds for more of you to vote. And yeah, 80% are correct, all of the above.
Yeah, it's a bit of a curveball, that one, but it's, you know, when you're talking about reasonable force, what's proportionate?
I'll hand back over to the gentleman, and this half will be a little bit shorter than the first half.
Yeah.
Ultimately, the High Court Enforcement Officer is wholly responsible for the entire site and executing that writ. They are as an individual, and there's no getting away from that. The authority is given to the HCO, and he has a responsibility of doing it effectively and efficiently.
And that's why it's the oldest secular office in the country. Effectively, it's lasted 1,000 years because of the personal liability.
And we'll go back to the original statement that engaging with the police to assist is very important. And because of the regulations, the police can assist us in enforcing it because we have a command over them. And we also have the power of arrest when we have a writ of possession. And the power of arrest is a fantastic tool in conjunction with warning them. We have a 5-stage warning the protesters, bringing the situation up at each level, and ultimately the final one is the power of arrest. It's very unusual to use it because we will use reasonable force to escort anybody off the premises, but without that, and under common law, it does move it into a different place.
Yeah, it's the fact is, if you're actually under a writ, then these powers apply, and by arrest we mean removing them from the site. What will happen is if somebody is unfortunate enough to push it far enough to actually get themselves arrested, then it'll be the police that charges them, and they'll be charged with obstruction. And it is quite, in my experience, I don't know, let's see, Occupy St Paul's 2012, there were 15 arrests, but that was because 14 of them were throwing fireworks. It was pretty grim, considering there were over 100 people on site. Proportionality was maintained, and it went extremely well.
So ultimately, all of the things that we've talked about so far is a big jigsaw of putting the operational planning together. We have some case studies that we can go through, however, time's against us. So if you do have any questions, they will be available at the end. But the police assistance is a big stakeholder. We sometimes have a designated area. Why would we do this? Risk.
Well, let's take a fracking site as an example. Balcombe. Now, there was a case where you have a long curving road leading down from a railway station, which is what commuters use to get home. The time of year, they're all arriving home at the station, it's dark. They get in their car, they leave Balcombe Village, it's de-restricted. Hey, national speed limit, 60 miles an hour, long sweeping left-hand curve, and right along both sides is an unlit protest camp. Never mind enforcement, that was an accident waiting to happen. And what was done as part of it, one of the requirements for actually obtaining the judgment was a designated protest area, which was a fenced-off area, which everybody initially said, oh, we don't want that anywhere near the entrance to the site. Well, sorry, they're protesting about what's going on the site. It was dead opposite. But it was also surrounded for their safety with 3/4-ton hay bales. It was quite an effective area. Killed it stone dead in the end. Okay, that's an example of it. Safety issues, risk mitigation, Gary.
Yeah, the amount of risk can vary from case to case. However, we have specialist access teams. As you can see in the picture here, we've got a lock-on being undertaken. There's 2 individuals through a cast iron pipe. We also have teams who work in confined spaces. The most recent one was Heathrow.
Heathrow, yeah, a couple of weeks ago.
And we have working at heights. Where we see this and we put into the risk operation is where they've got access to roofs or ceilings or in scaffolding units. We also have to have a responsibility to the protesters. I know that's another one hard to swallow, but we have to protect all persons on site, and this can be bringing in specialist equipment, especially with the.
Well, there's the tunnel at Grow Heathrow. Their air supply consisted of a 6-volt fan, and the battery had gone flat. So basically, we use a airline breathing apparatus, because the last thing anybody wants is an injury to the protesters on site, because it's not going to do anybody any favours. There is also the side to this. You might think, crikey, this is overkill, but actually it makes it absolutely clear to the protesters it doesn't matter what you do to try and slow us down or prevent us. The inevitable conclusion is vacant possession of the site will be given, and vacant possession, as we alluded to earlier, means the free and peaceable use of that site by the landowner. So in cases where you've got a risk of another incursion, effectively consult with your authorised officer and we will know the solution to that.
Another part is the designated area. Why would we use it? Because they have a right to protest, but it keeps the public safe, and it also gives them an opportunity to express themselves in a safe environment. And safety is utmost for any High Court enforcement officer. And we do this by controlled measures. Proportionality. Would you allow somebody back onto the premises? Well, occasionally we do, because we'll allow access to the site for exemptions for paperwork, passports, IDs, because we may have rushed this in the morning and secured the site very quickly.
You know, 7 o'clock in the morning we enter the site, and surprise, surprise, quite a few occupants have left for work. Now they're living there, they've got possessions there. You might argue tough. It makes a lot more sense for everybody if we can have measures in place for them to recover their goods, and also medication. One of the guys who came back to the site said, "Look, I'm on long-term medication. I need to get my meds." Not a problem. It's all been identified. Hasn't been disturbed. Pick it up. What it meant was, by midday on the second day, the operation, apart from the tunnel, was essentially complete. If you'd simply said, "Oh, well, you know, you'll have to claim it back later," that would have dragged on for ages.
So what we endeavour to do is have controlled access with the enforcement agents. By this time, all the hoo-ha and dancing is over with, and we've got established area where we can allow access for certain things.
It also prevents subsequent challenge to you. You know, the old chestnut with a protester saying, "Oh, there's a valuable Picasso on the wall of my greenhouse." At the time we enter, there is a visual, video and documented record of any goods and effects left on site. Notices under the Tort Act 1970, Interference with Goods Act 1977 are issued, giving the owners of the goods a period of time, generally up to 7 days, to collect their goods, after which time they will be disposed of by the involuntary bailey of the goods, i.e. you, the landowner. On that particular site, we did have two very unusual goods, actually. A 8.5 ton, 30-foot yacht that someone was restoring, and we gave him 14 days, and on the 10th day, he duly turned up with a crane. It cost him 1,700 quid, and he had it wedged out. The landowner wasn't left with a problem. It was actually quite a good bit of PR for how well it was handled.
So all of these is evidence gathering for the High Court enforcement officer in bringing this together for an effective plan. Through media communications, operations, start lines, and these are put into the operational plan, which is normally required by the police and the authorities. We share this with our clients and keep them abreast of all the information and the planning that's going into it, so there's full transparency of where we are, because it can move up and need additional resources, but it can also move down. And once it's moved down, then the operational plan becomes very dynamic. Some occasions, especially on the bigger sites, there's a protester liaison officer.
Please put them in.
And it's to ensure that both sides are kept safe.
And legal observers, you'll often get any number of people with high-bar jackets saying, "I'm from the protest committee, I'm a legal observer." Not a problem. One at a time, please. Generally, it's a very unusual sight. We'd have more than one, and we have no problem accommodating that. It's good from everybody's point of view, from a safety perspective and reputational management. They are quite closely controlled, but it works and works extremely well.
So in the operational plan, there'll be a deployment plan, which will be agreed by the police, which is normally up at silver level, chief inspector. If no overnight security is required, because it's going to roll over more than one day, and the policies and resources for any alterations for contingency plans. Grow Heathrow, some of the notable operations that we've done. I've
alluded to that in a couple of examples. This was a job where, in fact, this was a private client, and of course, the worry here was the cost. We were able to effectively, on day one, establish that got control over most of the site except for the tunnels. They were dealt with as quickly as possible. It was under 3 days. the result was the land was returned to its original use, and that's going out well. But it does show that in this case, the protest has been present for the better part of 9 years, and it doesn't necessarily mean it's going to be a very long, drawn-out operation. This one wasn't doing it at the right time, doing the right sort of level of liaison with people. Balcombe fracking, I mentioned the nasty curve. The fact is that once the protest had been made, activity on the fracking site had died down. We said there's little point in having a battle royal on this, because within 2 weeks there's something else happening. Support will disappear, and so it went extremely well. I mean,
so that was orientated around the operational planning, the intelligence,
again, and it was established.
And knowing that there was going to be a full protest on that site when it occurred.
Yeah, and once that was over and done, and the drilling equipment had gone, it went to a sort of care and control level. Interest dwindled. So, it isn't. Sometimes the right thing to do is actually nothing at all. Simply put it under control, have plans in place to deal with it if it flares up, and then see what happens. So,
this sounds very scary, David.
Well,
you
scary.
mentioned the nuclear part.
And as soon as you put the N word in, you think, oh, it's going to be a protest royal. Well, actually, the biggest problem there was protecting the protesters from the locals, all of whose jobs depended on it, and they rather made the mistake of setting up a trestle table in the local village, protesting the site, and then wondered why they got harassed. But this job is a good example, actually, especially for some people who are responsible in our audience for large sites or local authorities. It took place in the dead of winter. The biggest problem were the hazards on site from the weather conditions. And the last thing you want is a protester getting ill. And one evening, doing my rounds, I came across a young lady in a tree who was quite clearly unwell. And we were able to do something to help there. Not because we built up some wonderfully cosy relationship with the protesters, far from it, but clearly there was something wrong, and it was in nobody's interest if somebody got ill. But certainly, I mentioned Albury Arch earlier on as an example, Pall Mall. Rapid response was the answer here. Pall Mall was one where they couldn't go to the High Court. It was a few days after Albury Arch. The landowners couldn't go to the High Court. It went through the county court. It was done in under a week. So it doesn't necessarily preclude it.
Okay.
Quiz time.
Quiz time. So we'll have another few questions. But now, if you've got any questions, is a good time to ask them in the box that is in front of you. And if there are any, then we'll endeavour to get them answered at the end. Moving on to our poll questions. What are the benefits of using a writ? Please tick all that apply. The police are required to assist. Protects the landowner from wrongful arrest or assault. Police can arrest for obstruction, or police cannot stop enforcement due to a breach of the. I can't actually see what the rest of that says. Peace. There's a tick or apply. Would it be easier to say which ones don't apply?
Well, the problem that you've got is the police have, in fact, indicated that they will arrest the enforcement agents
for a fray.
If
it all kicks off. So it's back to the old chestnut about the level of reasonable force. Whereas if you've got a writ, the boot is on the other foot.
Whereas if any of the enforcement agents do overstep the line and use more than reasonable force, then the police will effect an arrest on them.
As is rightly the case. I mean, nobody should be deployed to a site who has not been specifically and properly and currently trained for conflict management, dealing with vulnerabilities, and at the very least, level 3 enforcement.
There we go. Which persons on site are potentially vulnerable? Please tick all that apply. Children under 12, university students, I'd agree with that one. Those showing signs of mental health issues, those under the influence of drugs and/or alcohol, or a protester locked onto a structure. Please tick all that apply. I'm really disappointed no one, 0% have gone for university students.
Most people can remember when we were at university, so I would say no, you're not vulnerable. You're quite good at bouncing back, but the rest of them, these are all categories of person that we regularly and routinely encounter on site. Children under 12, you wouldn't think very often, but actually, yes, we do. It's not an issue. It's catered for in standard operational procedure, and local authorities are pretty good with response to this.
The least amount of certainty seems to be about the protester locked onto a structure.
However, they are correct in their assumption, because a lock-on can develop very quickly into fatigue.
Yeah, and not just lock-ons. Protesters up trees. Take a protester, a couple of trees. They'd strung up a line between the trees with the breeches buoy type effect, and they were sliding from tree to tree. Great fun. But on about day 2, the line went slack. They hadn't tightened it up, and a young lady got in a position where she didn't have enough strength to pull herself back up the slope, and though in the tree, didn't have the strength to pull her in, and she was then in danger of getting a thing called compression trauma. She's sitting in this rather tight and restrictive harness. If you then get her down, all the blood is pooling in the lower extremities of her body. If you then get her down and release her from that, effect a rescue, what will happen is that blood, with all its toxins, will suddenly flood the kidneys. It can cause organ failure and heart failure in extremis. What became a protester removal transformed in an instant to a rescue. And I am pleased to say, in that case, most of the protesters up the trees, with one exception, assisted our team with putting the stretchers up there as fast as they could. It was good. So you've got to be careful with that. Protesters will put themselves in harm's way and sometimes won't realise just how much in harm's way they are.
Final poll for today is: whose safety on the site is the HCEO responsible for? Him, herself, and the enforcement agents, the police and the emergency services, the protesters, members of the public, everyone on site. Quite quickly, everyone's gone for the same answer.
And it is.
It is everyone.
Everybody. Yeah. Personal liability.
Yeah, that's common sense as well.
Yeah.
Which is really important for us.
And a weight off your minds. The buck. It's what I call an SEP. Somebody else's problem. Mine.
We have one question, which we will move on to. Is on the mortgage eviction, was the protest about the mortgage or about something else?
It was about the mortgage.
It was about the mortgage.
Yeah. It was one of these toxic mortgages, as they so called, and the social media had whipped up a lot of support. And it simply dealt with in the same way any enforcement operation of any form of writ is dealt with, in a proportionate manner. The biggest problem was maintaining possession over a period of time, and that was effected by a specialist security team that were put in. It's simply a demonstration that although problems can seem pretty intractable, the chances of us not having come across that before are remote. We've dealt with things in most sets of circumstances, from the smallest to the largest.
We'll round up, I think. I'll hand back over to you, gents.
So ultimately, whether the case is big, small, or indifferent, you can see the approach that we have, the professionalism, reputational risk mitigation. It doesn't need to be a big case, a single mortgage on a dwelling, right up to a full fracking and a site that's been there. The most recent one, 5 years, 6 years.
9 years, right?
Vast amount of experience, capability, and subject knowledge.
What he means is I'm very old. 36 years doing this.
And now I know it all. The teams that we operate with are highly effective and efficient, even though sometimes it can be a slow approach, because the slow approach is the appropriate one. We understand, and this is important, the reputational risk of the client, and we protect that, and we'll mitigate and do the operational planning to support that. With a proven track record of 100%.
100%, zero incidents. But funnily enough, you and I just finished doing the audit this morning. This will be sent off this afternoon. But it's dealt with by planning. It's by planning and having a team that's worked together for a very long time and know how to progress these things. And if anything happens on site, it's an unexpected incident. Actually, most things that occur aren't entirely unexpected, and that's the basis we work on.
We work on a case-by-case basis, because each one is individual. They're very similar, but individual because it involves people, and people can complicate things. And we can assist in the planning and preparation. Please don't go into these blind when the resources are available to you. The National Eviction Team does give a free consultation period at the very beginning, so if there's anything that's on your desk or that you'd like clarification on, by all means get in touch with us.
Certainly, I mean, any enforcement officer worth their salt, and they all are, will give you the appropriate advice. Beware of trying to get a rushed outcome, because it is not a good position from which to start.
So we'll work in partnership with you and the other stakeholders for the best outcome. We do operate on a transparent basis, and fees are always clear and upfront, and we'll give a best guide of what it's going to cost your client. So you've been listening today, because the time is up. David Asker on the left and myself on the right. Here's our individual details. Private mobile telephone numbers are displayed and our email addresses. If you want to have a word with us offline, by all means give us a ring, send us an email, and we can answer anything that's particular on your minds. No matter how daft the question is or how silly it may seem to you, please ask it.
Yeah, the only stupid question is the one you don't ask.
And once we stop laughing, we'll give you the best answer for your situation.
Yeah. You guys will be sent out a CPT certificate after this webinar, along with a copy of the slides. We also do have a survey post-webinar, so if you've got any feedback, we do appreciate it. So please do send you survey.
Especially with niche type presentations like this, we try and tailor it to our audience, and sort of with this one we've tailored it on some of the questions that have come up in the last 9 months to a year. But I do like to try and evolve these, and as the sort of society changes, different things pop to the fore and become as a problem for clients. So by all means, if you've got a question, forward it through to us, email it, we'll give you a sensible answer. I'll put you in touch with someone. If it's a really technical one, not necessarily deal with the enforcement side. We've generally got a library of people we've come across before. How do I deal with this? Livestock's a classic one. Your recent one with the cows, very cool. Yeah. Knowing the right people to call. Who are you going to call? Thank you.
Well, that'll be a goodbye from me, guys. Take it easy.
And it's goodbye from me.
And goodbye from me.
Nice. Cheerio.